May I please, Your Lordship?
Yes.
But I wish to mention for listing on urgent matter, my lord, I have filed an IA for extension of bail, my lord. What happened, my lord? The petitioner is convicted under POCSO for 20 years. He is released on bail for undergo medical surgery. He is cancer patient, my lord. His operation is fixed on tomorrow. And bail was up to 14, my lord.
14.
Lordship.
Okay, let it be on 13.
Obliged, my lord.
Yeah, please, yes, Your Lordship. Also, I'd like to mention item 13 of the supplementary list. Here, Lordship, I'm appearing on behalf of the legal aid counsel who is presently out of a station here, Lordship.
D Ghosh.
Yes.
I'm
Accommodation
appealing for
is
the
needed.
appellant.
Hmm?
I'm appealing for the appellant.
Okay.
Can
What
it
is
be
your
on
care?
15th,
We need some accommodation.
13th or 15th? Can it be on? My bail application is pending. It has.
Bail petition. 15th? Okay,
SK Chakmai.
Mr. D.K. Bhattacharya, learned counsel for the applicant is present. Mr.
SK Chakma.
S.K.
behalf of-
Chakma, learned counsel
counsel.
appearing for Mr. M.S.D. Ghosh, learned legal aid counsel for the respondent. Number 2 has sought listing of the case on 15th. So, as agreed to by the learned counsel for the other sides, lays the case on 15th. MS SH Bora, DK Bhattacharya, and MS SH Bora, learned additional public prosecutor for the respondent number 1, state of Assam are present.
Obliged.
I'm deeply obliged. Your Lordship.
Okay, may I please, Your Lordship? Lordship, I'm for listing of the matter 389 petition. Already pleadings are being completed, Lordship.
Maybe next week.
Maybe. Obliged.
May I please, Your Lordship? So I beg to mention item number 12, Lordship. Lordship, in this case, Lordship, my senior is out of station, Lordship. I'm paying for the adjournment, Lordship.
12.
Yes, Lordship, 12.
Yes, MS Bora.
Yes, Lordship.
Oh, yes, 12. So,
Next week, Lordship, on any day, Lordship.
it is not a fixed matter, so will not fix. You have got it by order and you have made the prayer for adjournment. Your name, please.
AK Azad, Lordship.
Mr. Ikhtajad. Learned counsel, you are there.
No, Lordship.
Learned counsel appearing for Mr. Ziuddin.
Yes, Lordship. Ji.
Learned counsel for the appellant. Has paid for an adjournment on the ground that Mr. Ziuddin is out of station due to personal reasons. Full stop. MS SH Bora. Learned additional public prosecutor for the respondent number 1, state of Assam. Any Asalsa Council, ASL, okay, is present, has no objection to the has submitted that there is no objection to the prayer of adjournment. As before, leave the case up. Appeal after a week on a date to be fixed by the office.
Obliged, Lordship.
I'm praying for listing the matter of WPC 1328/2023 for ex
criminal
gratia
appeal.
payment, ex gratia payment, ex gratia payment.
This is division bench.
Yes.
Yes. Okay. Fine.
Your Lordship has to appoint amicus curiae, Lordship, for the appellant. 1, 2, 3, Lordship, Zale matters.
And who is to be implemented? Any judgment is available here.
Lordship, paper book is not before us.
Complainant. MS SH Bora. Come on, learn it. additional public prosecutor for the respondent state of Assam is present. So this is an appeal preferred by the appellant from jail under section 374 2. CRPC Assam. Read which section 383, comma, Code of Civil Procedure 1973 against the judgment and order dated 13/10/2023 passed by the Learned Session Judge Dibrugarh in Sessions case number 97 stroke 2021, comma, arising out of ZR case number 26 stroke 2019 and Namrup Police Station case number 153 stroke 2019, comma. By the judgment and order dated 13/10/2023, comma, the accused appellate has been convicted under section 302, comma, Indian Penal Code. And he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, comma, in default of payment of fine, comma, to undergo imprisonment for further 6 months. Full stop. Where the informant is to be implemented, right?
Yes, Lordship. But that is not mandatory, Lordship, because
Is Lagan Gaur,
only in case of POXO matters, Lordship, as per Deepak Nair, you have to make party.
not required.
Not required, Lordship, just formal notice.
Okay. He should be implemented or not to be implemented?
Lordship may formally implement, but it should not go through registry to the respondent number 2 informant, Lordship.
It should go by registered post.
Not required, registered post.
Registered post will take steps.
Lordship, but in case of POXO only, that is mandatory, but
Okay. The appeal is admitted for hearing. Let the trial court records. Let the case records of sessions case number 97 to 2021 be called for. Full stop. Yeah, we are inclined to appoint Sri Anjan Kolita, as amicus curiae in the matter to represent the appellant. Full stop. In the meanwhile, the AO within bracket A, criminal appeal section shall inform the learned amicus curiae about his appointment in the matter. Full stop. The registry shall reflect the name of Sri Anjan Kolita as amicus curiae for the appellant while listing the matter next. Full stop. Para. Let a formal notice be issued without requiring any steps to be taken as a oral and additional public prosecutor has already entered appearance for the state. Full stop. Notice is made returnable on Bihur Bishop Oversight. 24 4 2024. Release the case on 24 4 2024, awaiting receipt of the trial court reports. Paperbook is to be made ready or what?
That has to be made.
After a trial court record.
Yes, Lordship, the answer may be called for you.
Next to enquire hobo. Trial to enquire.
Same prayer, Lordship. For amicus curiae, Lordship, one counsel is there, Lordship, MS Lachkar. His name may be given.
Sessions case number 06 within bracket M stroke 2022. Total additional sessions judge within bracket FTC -1 Margarita. I hold a terrible session judge here. Alright, session arising out of Lakapani police station case number 155 stroke 2021. Judgment in order dated 28/8/2023. Three zero to IPC. Rigorous imprisonment for life. And to pay a fine of rupees 5,000 in default of payment of fine, to undergo further rigorous imprisonment for 6 months. Mr. Mehbubul Hasan Loskur. Mehbubul Hasan Loskur. নাম তো আছে বাইকিনি কম্পিউটার কি সিম সিম এসএইচ পরে লিখে দিব উপৰত বাইকিনি কি আছে Issuance case number 86 within bracket CH stroke 2021 arising out of GR case number 278 stroke 2021 and for Dia police station case number 136 stroke 2021. Judgment and order dated 22/9/2023. 302 IPC. Rigorous imprisonment for life. Fine to 2,000. In default of payment of fine, to undergo rigorous imprisonment for further 2 months. আধা হয়েছে আধা এখন আধা পুরা লিস্টখন নাই
Lordship may appoint one B Sarma, MS B Sarma, stay Miss Lordship.
বিজিতা
Yes, Lordship.
বিজিতা শর্মা MS বিজিতা শর্মা amicus.
Item 4.
Please, your lordship.
Okay. Heard Mr. P.K. Das, learned counsel for the accused appellant, and MS S.H. Bora, learned additional public prosecutor for the respondent, state of Assam. Respondent number Respondent 1 from our state of Assam. This is an appeal under section 374 within bracket 2 of the Code of Criminal Procedure 1973. And the appeal is directed against the judgment and order dated 25/01/2024 passed by the learned special judge Sirang in special POCSO case number 22 of 2021, arising out of Talegaon Police Station case number 264/2022.
Item 5.
May it please your lordship. This is a statutory appeal, my lord, against conviction under section 366 IPC as well as section 4(2) of the POCSO Act, ma'am.
Item 7.
Meet your lordship. At time being possible, my senior key is my senior key is foot number D7. Time being possible.
Objection silent, sir.
What about steps?
It's not only taken.
What is the case?
Uh,
Under what section?
section conviction, section 6.
6. I think
Notice
service is
of the-
necessary.
Yes.
My lord.
Then last order. Okay. Last order reflects that the appellant has not taken any steps for service of notice. Let us see the office note. Neither ID card nor answer notice has been received.
Notice which one is.
So notice
Anybody?
registered for.
Likhit हुआ उसे ना.
If it is POCSO, whether under for this 389 application,
Yes. Yes.
same mode.
Yes.
Then here it is sent by registered post AD.
Or 2 hours only under Deepak Nayak's judgment.
See,
Yes, ma'am.
main file to song. That order is not there perhaps. See this order also. Right. Huh? See this main file also. That kind of an order is not there.
Yes. Not there, as per Department just.
That is mandatory.
Myla.
Step was taken.
Oh,
Huh?
scan copy আমার দিব
Some order here.
অফিসার
What is the appeal order? Ako sa
Older more Department judgment.
Okay, so order. MS Bhuyan, this is to be complied with.
Yes, ma'am.
That order is to be in the main appeal.
As well as in the I criminal. Oh. Oh. তারপরে process করে দিয়ে দিলাম। Apply গুলো করতে না। বিপাশা ফোন করা আছে process মানে দেবে।
And Islam.
And Islam, Learned Council for the appellant, and MS, B. Bhuyan, Learned Edition, Learned Senior Counsel and Section of Public Procedure. For the respondent of state or some, from assisted by MS, M. Soikia,
চক্রবর্তী
Chakraborty. Reason appeal against judgment and order of conviction and sentence. Under section 6 of the Prevention of Children.
Lordship, they are convicted under 302.
198 of 84 about the people.
Agotu was a pending, say, but this I has been filed, Lordship, because one of the appellant is suffering, Lordship, and he needs surgery, Lordship, and I have annexed some medical documents. Lordship may obtain a report from the jail
Yes, we'll
authorities,
do that.
Lordship.
Yes, could do that.
It's
Yes.
district jail, Dorong, Lordship.
Heard, Mr.
M. Ahmed, Lordship.
Mohammed. Learned Counsel for the applicant's appellants. NMS B. Bhuyan. Learned Senior Counsel and Additional Public Prosecutor for the respondent state of Assam. Full stop.
Yes, sir.
The applicants. Comma, tree number, comma,
Again, you know,
as appellants have preferred the connected appeal, comma, criminal appeal number 213/2023, comma, which is pending. The said appeal
into jail.
District jail.
is preferred against a judgment and order dated 25/4/2023 whereby the applicant's appellants have been convicted under sections 302/34 IPC, and they have been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 5,000 each, with default stipulation. In this interlocutory application, it is stated that all the three applicants are presently undergoing their respective sentence. Full stop. Insofar as it is further stated that the applicant number 1 has been suffering from various ailments since 2023 and to October 2023. And he has been receiving medical treatment at the Mongolway Civil Hospital under the supervision of the jail authorities. It has been averred that the treating doctor of the Mongolway Civil Hospital has suggested better treatment at the Guwahati Medical College and Hospital, and also suggested surgery of gallstone and kidney stone immediately. As such treatment required urgently, such treatment in respect of the applicant number 1 is required urgently, the instant interlocutory application has been prepared, seeking entirely a direction to the jail authorities to provide necessary treatment and to conduct necessary surgery and to facilitate the necessary surgery of the applicant number 1 at the Guwahati Medical College and Hospital as in an expeditious manner. Full stop. Para MS Priya. State Council shall obtain a medical report from the jail authorities regarding the health condition of the applicant number 1, and also an opinion of the treating doctor, if available, as regards the necessity of surgery. Surgery for the applicant number 1. Yes, when?
Lordship, either on 15 or on 18th. 15 is Friday, 18 is Monday. 18, madam.
List. Yes, on 18.
Lordship, may I get a copy of the order?
Let me close it. A copy of this order to be furnished to MS Priya. For the purpose of taking necessary steps from her end.
I would like.
You to lead a peaceful life,
Right.
but otherwise maintainability of such an application before this court, I am having some doubt.
Lordship is correct.
Data ta didi ko. Data.
Data. 10-4.
For hearing item number 10.
Yes, Mr. You are opposing or what? Is there something in Supreme Court?
Maybe it may be on record because what happened, this court convicted against acquittal.
First, it was an decision appeal against acquittal.
Acquittal.
Yes,
my lord.
Lordship.
Then there was a judgment
Yeah, the-
by the division bench,
Yes,
reversing the
yeah. my
appeal
lord.
against acquittal.
yes, in respect of five.
And what happened, thereafter,
Then matter was forwarded to the trial court for something,
recording
Yes.
statement,
huh?
sentence hearings,
Sentence hearing. In the meantime, somebody
died.
died and somebody appealed.
Appeal in
Some
Supreme
level,
Court.
because so lower court has given the date of probably in May.
24/5, I think.
Date is given day one time because they want to examine you, one of the
That is not the sole issue also. Because how many against how many it was reversed?
five.
Five, Lordship.
5. It appears Mukteruddin.
Yes, Lordship.
Mukteruddin approached the Supreme Court.
Yes,
Supreme Court allowed his bail
yes.
and called for the
Yes, yeah.
LCRs, scan copy of the High Court record
As well as.
and the trial court record. Suppose that appeal is pending
Yes,
and that because it is reversal of the
order of
Acquit-
acquittal.
acquittal. Now, it sets aside the High Court order,
Yes,
then
It is better, long date should be given until the order of the Supreme
still
Court
it
comes.
is pending before the
Ah.
Supreme Court, Lordship.
Long date should be given so that it comes something in between.
let it be after 2 weeks because the other court, I am sitting here, like, I'll not be able, but regular court will be sitting.
Lordship,
So that let them take care of it,
Lordship after 2 weeks.
right?
Yes,
Because if we, after sentence hearing, suppose,
yes. So it may be after May, Lordship.
Long date may be, no
it
problem.
be after 4 weeks.
Giving a date, no problem. Long date.
There is no representation.
Yes, Lordship.
They
There
are
is no
not a-
representation on behalf of the,
Convicts, convict.
Acquittal, Lordship.
who is the appellant?
Appellant
He has
is,
not come.
has
Ah.
not. come.
Appellant,
Ahmed.
Yes.
appellant, today on call, post of, MS S.H. Boral and additional public prosecutor for the state of Assam. And Mr.
Informant, for the informant.
Mr.
Ayalam. Yeah, Alam.
A. Alom. No, you are the appellant or what?
No,
Yes,
madam.
for the respondent, Lordship.
Huh?
Respondent.
I
number
was
two.
for a respondent and informant. That's it.
Okay. No, you are the appellant.
No, madam, I did not.
Appellant
Yeah.
is absent, Lordship.
No.
You are
not understanding it.
Lordship is right, very right. Lordship is very right. What happened, yes.
You are the appellant.
After
Okay.
judgment,
Just because,
It's a reversal order.
yes,
because the appeal, see,
against acquittal.
in the trial court, you got, the other side got acquitted,
Yes,
right?
yes,
Other side got acquitted. Then you come this side. You have preferred the appeal. You have preferred the appeal.
This one.
In the appeal, the court has reversed
Reverse the acquittal.
The-
That's the acquittal.
order of acquittal. And the matter was sent temporarily to the trial court for sentence hearing.
Sentence hearing.
That stage was not complete,
Not completed.
right? In the meantime, 2 died, that is one matter, but one, Mukteruddin,
yes,
he approached the Supreme Court.
yes,
Supreme Court, there he got the bail also. And Supreme Court has called for the High Court record
Yes.
and trial court record.
Yes.
You are still the appellant. The appeal where the order of acquittal was reversed, that has not culminated.
Yes.
But the complication has arisen because of one Muktiruddin
Yes.
has approached in the meantime
Let's go.
to the Supreme Court.
Yes.
And Supreme Court has granted bail also.
Yes.
The others were asked to surrender,
Mhm. Yes.
right?
The four. Yes.
There is a position.
Yes. And my learned friend is appearing for respondent number 2 to 10. Yes.
Mr. Alam, you go through the records also and take your call what to do. Yes, MS Bora, what to do.
Lordship, since the matter is pending before the apex court, so in the meantime, Lordship, it is only partly allowed, Lordship. Appeal is partly allowed. So,
Party allowed me.
Lordship, in respect of out of 10 accused, only 5 accused has been granted acquittal and others are convicted, Lordship. And one convicted person has,
Okay, let it be by after 4 weeks. So you mean try to get information in the meantime from the Supreme Court.
Other also, my lord, in view of the
Appeal number 583,
yes,
okay, of 2023, Supreme Court.
yes.
my lord, yeah,
Heard Mr. Alam, Learned Counsel for the appellant, sole appellant,
Appeal and Lordship.
appellant. And Message Bora, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, and MS.
Henrietta Thakuria, H Thakuria,
H. Thakuria, Learned Counsel for the respondent number 22.
10.
And how many of them died?
It's only more.
No, no.
Only more, isn't it? Nine.
For the surviving respondents.
Yes,
For the surviving respondents. Surviving.
yes,
For others, it might have abated.
yes.
Few died, two perhaps died.
One more, sir, one more.
Don't know. Okay.
maybe it was wrong then. Because actually it should be stayed. The High Court can stay. Because Supreme Court matter is pending before the matter.
I think Honorable Justice Surana,
Yes,
he has in a note sheet
yes,
made an note, endorsement that may be listed in a column to be spoken to.
Lordship,
So let it be
After court.
before him.
yes,
So, in view of the note endorsement. Dated 2024. So, as sought for by the counsel for the parties, this is the case in the next.
Lordship,
I think, but Honorable Justice Surana will be,
Lordship,
I don't know for what he has said that
Yes,
for
there's a
be
note,
spoken
yes.
to and all this.
That
endorsement has been made.
the case is pending before the Supreme Court and all, probably the Honorable Court
Yes.
wanted to convey.
No, he has made an endorsement.
Yes,
Yes.
madam, for that is because.
So let it be the next week.
yes, organized.
May I please your lord.
Yes.
My lord, actually, I will be led by Mr. Senior Edward Kamar. He's on leg, and suggested me to start, madam. So let me start, madam. My lord, this is an appeal against the conviction and sentence passed by the learned session judge Karimganj. In this case, my lord, all the petitioner's appellant, Abdul Khalek, was given, and the other persons who are given life sentence. In this case, my lord, there are 8 witnesses who are examined by the prosecution, whereas 5 witnesses who have been cited as the witness of the prosecution have left over, and it was the defense examined them before the court as a defense witness, all the 5 witnesses who have not been examined by the prosecution. Now, your lordship will find that the FIR is at page.
Let us see the charge sheet first.
Charge sheet minute.
List of witnesses.
Yes. Page 102 page number.
Now, whether DW1,
Yes,
Abdul Rauf,
yes,
listed witness,
yes.
let us see his number.
Minute, 10,
Hmm.
Abdul Rauf. Abban Ali, then Charge Ali, Afzal Ali, Nazrul Islam, Firoz Ahmed. All these witnesses have been left out, Ansar Ali, but examined by the defense.
Oh, is it? What is the legal proposition? Otherwise, suppose
Well, there is Supreme
Then-
Court judgment on this aspect.
just I'm asking
Yes, yes.
that suppose 20 listed witnesses in their charge. Prosecution has decided to examine, say, 10,
Yes,
and they left out the others,
yes.
other 10. Then the defense decided to examine the other 10. In such situation, what is the legal proposition? How this defense witness will relate their testimony to their previous state.
In this case, my learned session judge who are deciding the fact,
I am asking the
Well,
legal
the-
provision.
the-
I am not
My
asking
humble
about
submission-
session judge. You are a
their
seasoned
evidences have got a,
seasoned criminal lawyer, whether these defense witnesses are free to depose anything or they should confine their statement.
yes, their statement.
That is what I am asking.
There should be confined to their
Yes,
statement.
Bora, what is the law?
Lordship, actually.
I want to know
Yes,
first
they
the
are confined to their own statement.
standard on which we have to.
Yes, yes.
What is the law?
Lordship,
Suppose
yes,
20 witnesses were listed in the charge sheet
yes,
by the prosecution,
yes,
meaning thereby almost all of them are, their statements are recorded under section 161.
yes,
The prosecution during the course of the trial had decided to only bring 10 witnesses
Lordship,
to bring home the charges against the accused,
Lordship,
and they left out 10. Now, since these 10 were not examined by the prosecution, the defense decided to reduce their evidence.
yes,
Now this defense, because their witnesses are all, their statements are also recorded,
yes,
right, previously.
yes,
Now, I am asking the proposition that what is the legal proposition
yes,
that how their statements are to be looked into,
yes,
because Mr. Biswas or the defense witnesses, they cannot be allowed to go free and say everything,
Yes, they cannot.
they cannot,
right?
yes,
They have to stick to their previous statements.
yes,
Only then it will be reliable.
yes,
I think
yes,
this is, I have not considered this issue earlier,
yes.
so I am not.
Lordship, absolutely.
So
correct.
what is the law?
This is
I
the-
want to be sure on that.
Yes.
Then our things will be very clear then on what standard we have to
Follow, yeah.
put the defense witnesses,
Yes,
because they cannot go haywire
yes. They have to.
and speak according to their imagination.
Yes,
They have to be within the, perhaps, they
Yes.
have to be within the four corners of their previous statement.
the lordship is very.
What is the law? You
Lordship,
both are seasoned
yes, in
criminal lawyer.
There is a judgment of Supreme Court. in this.
That,
I will give, my lord. Yeah,
so
we have
that then my perception will be clear
yes,
while proceeding with
it must be
reading
con-
of the,
It must be considered with the same evaluation.
what is the law then?
My lord, I
Because
hope
they
I can
cannot
give-
give flight to their imagination.
yes,
They have to be within the four corners of their previous statement.
yes. Yes.
Because there are many things which might happen in the meantime,
It can.
that they may be
There will be,
won over.
yes, yes,
They may decide, no, let us, if they, all the witnesses are from the same locality,
yes.
let us decide to have peaceful life.
There might have some compartments within the witnesses.
All these are there. There may be some element of coercion also,
Threatening also,
pressure also,
yes.
because that is why I am asking that
Yes, yes.
what is the proposition?
And that
Yes, madam?
My lord, give me some time, I will find out. Let me submit other matter. Submit
No,
other.
because
It is very important.
question
yes.
is,
Yes,
here the question is, see, this has, this bears importance.
yes, exactly.
Because 8 prosecution witness, 7 defense witness.
Seven defense.
That
witness.
is why I am
Yes.
asking you.
I'll bring you, Lord,
Yeah.
my lord. Kindly,
Yes,
submit the other material, kindly.
Can you have some,
Yes,
in fact, Lordship, my learned friend as Bhuya was supposed to do the case. This says,
S Bhuya, B Bhuya?
P. Bhuya, sorry. Lordship, I didn't go through a file. Lordship, give us some time.
Because it is long one, evidences are long ones.
yes,
I have to be clear in my
Yes,
mind, Mr. Vishwas.
yes.
That what is the law?
yes. The lordship is
Because
very-
it is 8 witnesses versus 7 witnesses.
Seven witness.
Everybody will be saying, it
Yes,
is not that 3 witnesses versus 2 witnesses,
yes,
8 versus 7,
yes,
and all are listed witnesses,
yes.
Yes.
right? Now, whether it is permissible in such situation to look, because I had just had a glance
Yes, sir.
in the defense evidence,
Yes.
they did not refer to their previous thing. I just had a glance of DW1.
Yes. Yes.
Now, whether they are permitted to take a flight of imagination,
Yes.
whether court is powerless to look into their 161 statement.
Yes.
Not at all.
Are you getting my point?
Yes, yes, exactly correct one. Exactly.
If I cannot, if this statement, all these defense witnesses cannot be taken into face value,
Yes.
and if the court, just because the previous statements are not brought either by the defense or by the prosecution, in such situation, whether court can look into their previous statement to know about their
Veracity of-
Credibility.
veracity and of this, because this is very important. Because otherwise, if the court is not taken to previous statement,
Yes.
either by the prosecution or by the defense, to put to the IO, these are not to be looked into by the court.
Yes.
But what is the legal proposition in respect of such a situation? You do not, your season
No, I'll give you my, tell it.
we can take up tomorrow, you can give the proposition tomorrow, because no way, otherwise you put me, will be in a difficulty.
Yes.
Yes, tomorrow.
You are not in a position to provide me the proposition.
No, I have gone through, but I have to find out, but that's why.
As on today,
It will take little time, my lord, that's why.
This is a core issue also.
yes,
that is the
because
point.
I have to look into that.
Yes, yes.
If you, if I do not, I'm not permitted to look into, then I'll not look into.
Yes, yes. also is
But
very
if the
correct.
court is permitted to look into, I'll look into,
Yes. also.
to test the veracity of these witnesses. So far, prosecution witnesses are concerned, my concept is somewhat,
Yes.
at
Yes.
least I understand
Yes.
how to deal with it.
Yes.
But defense witness and similar to this one,
Yes. I have got your point, Lordship's point.
what's your point?
Yes, actually.
Because you will say this fact, this fact, this fact, this fact.
Yes.
As simple as that.
Yes, Lordship.
And your burden will be over.
Yes.
And court will be left with a burden how to do little legal proposition. I am not accepting.
Yes,
this.
Lordship. Your Lordship is correct.
If the council is not for assistance of the court, court is not taking up any.
Naturally.
Lordship, kindly give us some time.
Am I clear?
Yes, Lordship.
Yes. Because I have not come across.
Yes.
Had it I been aware, I would have started
Yes.
without doubt. But I need the authority. Merely by saying will not do. Am I clear, Mr. Vishwa?
Yes, yes. Your Lordship.
Find out amongst the decision you have carried whether this proposition is available. I will not read the statements
Yes.
one time, again after knowing the legal proposition the second time. 7 witnesses. It needs labor.
Yes.
If it is permissible, I'll keep this previous statement beside me. Open.
Lordship.
Yes,
Eighty লাগে।
I am just making some query.
Judgment বিষয় আছে দাও।
I am making some query.
My
Just because there are 8 prosecution witnesses, 7 defense witnesses. All these are were listed witnesses in the charge sheet.
Charge, correct.
Meaning their previous statements might have been recorded under section 161. Now, so far prosecution witnesses and their veracity, testing their veracity with their previous statement, that perhaps is somewhat known. Now, suppose, because here it is not 2 or 3 witnesses, it is 15 witnesses.
Right.
Now, defense witnesses, which are defense adduced, listed witnesses, meaning thereby their previous statements might be available in the
Case diary.
right. Now, question is, how their evidence is to be tested, right? Firstly, I just had a glance at cursory glance at DW1. There was no reference, though he has stated, I made the statement, maybe, but there was no reference
Regarding his.
by the DW in his chief or by the prosecution who cross-examined him in his defense. Now, because they were listed, it cannot be that they should be allowed to give flight to their imagination and say whatever they like.
That is one.
You cannot, you have made the statement within 4 corners, previous statement. Now, whether they can give flight to their imagination in their DW because they were not examined by the prosecution, or because there is no reference. In such case, to test the veracity of these witnesses, whether since neither defense nor prosecution referred specifically to their previous statements, whether it is permissible for the court to test their veracity to look into their previous statements. Because otherwise, if it is simple prosecution, so what is the authority?
First authority is that there is no distinguishing feature between PW and DW. They stand on the same pedestal. Now here the only twist is that they were once listed witnesses, thereby meaning there must be 161, but not necessarily. Why I say so? Because sometimes they may be Caesar witnesses or not throwing lights on the facts of the matter.
Caesar witnesses
That's what I'm saying. So we don't know the characteristic right now.
We have seen one at least. Let us examine that.
Yes, my lord, that is one
DW.
aspect. And second thing, my lord, as your lordship knows very well, my lord, that 161, including 164 also are not substantive
1 minute.
evidence.
Or then 1 minute, just to
Sure, my lord.
say for example, previous statements recorded in respect of few. In respect of few others, it was not recorded.
Right.
Then how these 2 categories are to be categorized? Because I want to read the definitions with the legal proposition clear.
Absolutely, no doubt of it, my lord.
Because I do not want to read twice.
Yeah, sure, my lord. But before addressing that, I'd like to throw light on the legal aspect, my lord. These are not 161s are not substantive evidence. More so also 164. So whoever comes in the witness box, takes it on oath and depose, my lord, are only substantive evidence. So it was suppose the defense has not examined all those aspects, my lord. So in that event, it was the bounden duty of the prosecution to bring it, my lord, by way of contradiction. Let's see, in your 161, you have stated that. Now you are resigning from your earlier statement. That would have been a way of cross-examination, I feel like.
No, here feeling.
No, I feel
There
like
are
that's what I
many
am
feelings
submitting.
also. There are many feelings also.
My lord, that's true. my lord.
From all sides.
Well,
From your side, my side, people's side.
Three
To
sides.
not cleanse the issue.
Absolutely.
That is what,
That's true, my lord.
this is my comments.
From my viewpoint, it will be like this.
Do
my
you
lord.
have any authority on that?
Oh, yes. Authority as such, so I have not gone for this because as your lordship knows, first the prosecution should produce the base evidence from their side. Second thing, if the prosecution is not able to lay the foundation of the case, my lord, they cannot take the weakness of the defense side. So prosecution must stand on his own legs, my lord. Thereafter, corroboration or contradiction may be sought for from the DWs, my lord. That is the basic golden principle that I can throw light.
To an extent, that is.
General
To an
position, my lord.
To an extent, it is known.
Yes, ma'am. Absolutely.
Well, what are this proposition I have put?
Yes, ma'am.
What
Now,
is
on that line, I have not made any research work, but on other points I have made.
Because if it is not required to be looked into, I'll not look into.
Right, ma'am. No, first we will
Look,
have.
see, no, see the labor. Mr. Kamar, please. There are labor of going through this 8 prosecution. With.
Right.
Suppose I feel that I need to go through the
DW.
7 DW also, but I don't know about the legal proposition. Then I'll be without the assistance of the
Councils.
lawyers. That is what,
What I will first respectfully submit, my lord. First, the prosecution has to establish their own case on their own strength, my lord. Then only the
if you
question.
do say that I'll not rely, then I'll proceed.
Yes, ma'am.
Otherwise, give me the authority.
Basically, my lord, I'll be relying on the evidence of the prosecution witness per se, my lord.
You are referring to any DWs?
The DW, of course, here and there will have to
You give me the
move, my lord. But basically, DW.
rely, then I'll not. I'll record first thing that defense lawyer is not.
I could get your lordship mind. my
I am
lord.
so,
I
I'm
could-
making my position.
Yes, my. I got your
I
lordship.
do not
my
want
lord.
to be in a
Double.
no man's area.
Yes. ma'am.
No man's land.
Because the DW normally are vulnerable witnesses. They have examined it. Now it's brought on record, so we'll have to proceed by it, my lord.
Hmm?
We have to proceed by it, my lord, since it has been brought on record, my lord.
Tell me if neither this and prosecution also examined, defense also did not refer while giving deposition, DW1, suppose he does not. Let us 1 minute. Let us, before going into the reading DWs. No, I want to be clear.
Right, my lord. No. Because first let us check who are the main
Let us see, say for DW1,
charge sheet.
without into the contents, just to find out. Did he refer or not?
I don't think they have referred it on my plain reading, my lord.
DW. Says police examine me.
Charge sheet, Abdul Rauf is DW1, my lord.
Now, page 34.
Yes, my lord.
Police second line.
Now, it starts from
Hindi.
33, my lord.
34,
34 is the,
34 second line.
yes.
Police examine me. Now, DW1.
And he is cited as charge sheet witness number 10, my lord. After
Page
all, son of
38.
Gate Mazud.
Police examine me.
My lord, can we first cross check the list, my lord, whether they were charge sheeted witness or not, my
I have checked.
lord. My lord.
All 7.
After Ali,
I have checked. I have marked also.
but I don't see after Ali, my lord,
No,
DW,
he's there. DW2.
son of late Gabbar, PW.
There. Page 38.
Yes, my lord.
Line. First 3 words.
DW.
Yes, DW2 is PW8 in the charge sheet.
Yes,
Page 38 or a paper book.
Yes,
yes.
ma'am.
Police examine me. DW.
Accordingly stated before the police. So police might have written some else 161. So that's why I said at the outset, my lord, that whoever comes and takes the witness box and depose before the court on oath, my lord, is the substantive evidence. That can be only looked into, my lord.
That basic
Yes.
principle is known.
No. But what is the legal proposition?
One cannot take advantage of a situation
My lord.
at the same time. Just because this witness, because prosecution is best in a best position to call how many witnesses, and if they are confident that we can bring home the charge by calling this number of witnesses, they can call it. That discretion is available.
Correct.
Just because prosecution did not examine few of the listed witnesses, one cannot take advantage of that situation and produce the witnesses and allow them to say whatever
No, that was basically prosecution witnesses.
substantive evidence is to be tested also on the say situation. Suppose
One more thing, your lordship is also aware, my lord, that regarding non-examination of the material witnesses of the case also is also vital to the prosecution.
there is 148 presumption is there.
Absolutely. 114G.
That is there.
Everything is there, my lord. Only we have to put it.
Only I am
The court, my
putting this question that whether they will be allowed to give light to their imagination,
No, that is for appreciation of evidence.
how to deal with. What is the
That
authority?
your lordship will discard
I'm
it.
putting,
Your lordship may discard it if it is giving.
No,
light
no,
to
what
the
is the-
imagination.
maybe there are many, I am, as a senior counsel, I am
I'm trying to address it.
seeking the assistance that is there any authority or
Right
no
now, I don't
authority?
have it, my lord. Neither I have examined to that aspect, my lord.
Because
Since
it
it
has
is
to
from
be
your lordship,
also
I'll
in the
definitely-
four corners of the law.
Absolutely.
I cannot, if I am not permitted, I should not look into their 161 statements. Am I clear?
But I remember, my lord, but I cannot say right now, my lord, if the prosecution has not examined, the defense is within their legal right to examine it.
All these are saying and nothing.
Yes, ma'am. But now your lordship needs an authority for which I will be seeking some time to bring it on record, my lord. If I could.
Because I have seen at least everybody has said, I gave statement, police examined me. I gave statement to the police accordingly. It is there. Right, I have seen at least 4 of them.
Majority of them,
Police recorded my statement.
and I have stated as such before them. Now, police has written what they,
Now suppose prosecution has elicited from this defense witness. Just I am,
imagining it.
the police, they admitted, police recorded my statement. Now, in such situation, whether the court is permitted to look into
Definitely, madam.
previous
Definitely.
statement.
Your lordship will look into. But while appreciating it, while taking into consideration, your lordship will filter it.
I want to,
No, madam.
from a senior counsel, I am,
No,
this is not the expectation.
senior counsel doesn't have a magic wand, my lord, that immediately it will come out, my lord.
I am.
That aspect we'll have to look into, my lord. But right now I'm addressing in the manner which I have been learning all these days, my lord. So for that exactly pinpoint judgments will be probably difficult because these are very
Because-
rare incidents, my lord. But
To be-
definitely there will be something.
To be frank, I am not in touch with criminal law.
No, your lordship is
Yes.
much well versed, my lord. We have
So,
got the test.
I have been putting you
No,
across.
very rightly and appropriately put, my lord.
To what extent
It can be looked.
they can be looked into this defense witness
Right.
this particular situation. And it is not that 1 or 2,
Yes,
it is 8 versus 7,
more than prosecution.
almost. If you say leave this IO, then it is almost equal.
Yes,
So this
Balance.
then.
Blanche, how to look into this?
Right. Now, had it been a normal DW, things would have been different. But when they are having previous.
Listed
evidence,
witnesses,
yes,
that is what.
listed,
Yes.
Because whether they have to give in same weight. Because prosecution witnesses I know about how to their previous statement and all these things,
Right.
but I'm not aware.
No.
I'm telling you frankly
No, no, my lord. So am I also, my lord.
that
Because normal defense witness, I can lay hands easily, my lord. But
that I know. That I also know.
yes, my,
That I also know how to appreciate.
absolutely.
But so far as these listed witnesses are concerned, where their previous statements are available,
Yes, correct.
right? That
How-
is the what I am.
And also one thing probably, your lordship, will keep it in mind, how much of that previous statement now can be used by a defense?
Right. Both by the defense as well as the
Well,
prosecution, by the prosecution.
Absolutely.
This is what I am finding difficult with, that I am not,
I
I am not come across.
right. For me also first time, my lord.
This is no, this has just come across my mind.
Yes.
So, because reading without knowing the legal proposition will be an exercise in futility,
Yeah.
Right.
and we'll come back again after 2 days, and then we know. Then again I have to read to screen the.
Yes.
Can you come back, say, day after tomorrow?
I'll come.
I think.
I'll come. My lord, it is a good legal aspect which we would like to read again and again.
Because I want to know.
Yes, Lordship, that's very good.
What my doubt is.
On 13 we can come. On 13 we'll be before your lordship. On this point, I'll try to find it out.
Okay, 13 release, probably ever. 14? 14?
We'll manage it.
Yes, Lordship.
14. Okay. We just
My lord, I got it, my lord.
Jade Kamar, Senior Counsel, assisted by SCP Sage Moral and Additional Public Prosecutor. For the state of Assam, is the case on Thursday. Because I want to know, this is
No, my lord.
interesting one.
I'm also obliged, my lord.
What extent
certain
one-
important law points has come in, my lord, and it's my duty as a senior counsel to point it out.
That is why
That-
I waited for you also.
Yeah, my lord. Absolutely.
Because everybody has spoken very lengthily. Yes, MS Bhuya. I am putting one query
Lordship,
to you.
What
lord.
important law point has
Oh,
come?
oh.
I am putting one query.
My lord,
Here, total 15 witnesses were examined
examine.
during the trial.
My lord.
8 by the prosecution,
Yes.
7 by the defense. All these were listed witnesses in the charge sheet.
Well.
And out of this, prosecution decided to examine few and left few. Left out few. Now defense decided to examine those listed witnesses who were left out by the prosecution.
Okay. Oh,
Am I clear?
my lord. Lordship,
Or you take the paper book.
paper book,
Come to 102.
page 102.
Hmm. Right. And also the index at the same time. Index.
Oh, I don't have the index. Yes,
Both
there.
together. Right. Now this DW1, Abdul Rauf. Right.
Abdul Rauf, yes.
You come to page
PW
104.
104.
He is listed witness 10.
Abdul Rauf. And let us see.
Same size.
No, no. Bape ko naam, sir.
Okay.
Oh.
It will be him. It will be him only.
My lord.
Similarly, DW2, Akhtar Ali. He is listed witness number 8.
Yes,
DW3, he is listed witness number 6.
my lord.
Similarly, all,
Hmm.
right? These were not examined by the prosecution, though their names were in the charge.
Charge sheet.
Prosecution examined,
Names appear in the list of witnesses, it's there.
prosecution examined, including Dr. SI,
8,
8.
my lord.
If you leave out Doctor and SI, IO,
Yes,
prosecution examined only 6.
yes.
Defense examined more
Oh,
from the listed witness.
yes,
I know about the proposition, how this is to be tested,
Right.
prosecution witnesses with their relating to their previous statement,
my lord.
right? Now come to the defense witness. defense witness, they have said, police recorded our statements.
Yes.
But neither the defense nor the prosecution, while examining them, put the contents of the previous statements to them. Suggestions might be there. Whether in such situation where a defense witness has been examined by the, when a witness, listed witness of the prosecution has been examined by the defense and their previous statements are available, whether such defense witness can can state anything, or they have to confine themselves to the four corners of their previous statements.
Yes.
Right.
Yes, Lordship, and now I got the point.
You have got the point.
Yes,
Otherwise, if suppose, and there could be some situation, prosecution has the discretion to examine, there may be 100 witnesses, they may examine 50, and they feel satisfied that we have been able to bring home the charge. Now, defense will pick up the balance 50. And you go and say whatever you like.
like,
It becomes, every statement will be your contradiction. Can you be permitted?
Lordship.
Have you understood my point?
Yes, yes,
So,
understood.
whether such a defense witness, not any, such a defense witness can be permitted to adduce the evidence or give his testimony in any manner what he likes, or he should confine himself to his previous statement while deposing as DW1. Have you got my point?
Yes, my lord, that factor I have to look into in the light of judgments. But at the face of it, if they would not have, they have not stated anything in
Any idea you will
161.
come? In my mind, there will be three theories. Mr. Kamar's mind, three theories. Ms. MS Bhuya's mind, three theories.
Yes.
This should happen like this. This should happen like this. And court will think this should happen like this.
Actually happened,
Yes.
we should.
Lordship.
What
probably
must happen?
My Learned senior friend is vast experience.
No,
That is
My
why
limited
It's only a
experience.
learning.
Whether it would amount to improvement, my lord, if they have not stated anything in 161.
otherwise, see, suppose prosecution
First
witness,
time in the court.
prosecution witness is also always to be within the four corners of the previous statement.
Yes.
Otherwise, defense takes care of him by putting him everything, these things, see, and then to the IO. Got the contradiction established.
My lord.
I know about that
I-
part. But so far this, I don't know.
Venture.
No, time is-
I have to frankly admit,
14,
we are putting on Thursday,
14.
Thursday will.
that will facilitate
My lord.
to look into all these statements and to know that whether we will look into this, required to look into this DW or previous statements, even when, to test their veracity, even when the prosecution nor the defense have specifically made reference to their previous,
Previous statement.
because we have to call out the truth only.
Yes.
Try to call out.
Yes.
Try to call out.
But just academically saying so, my lord, normally 161 will never be in favor of the accused persons. 161, I think. But when it comes in the deposition, that is only to be looked into, my lord. That will be only looked into by the court.
But
Because that is what I'm submitting, my lord. Now it was the duty of the defense also to bring it, that you on your previous statement has stated like this, now you are resigning from it. So that aspect is also to be looked into. So
because while reducing, you become the prosecution side almost,
absolutely,
and they become the defense side.
defense.
Whether same formula is to be used.
Yes,
You find out that.
will, my lord, just throwing light so
Ah.
that we can look into in a better perspective, my lord. Actually, now on discussion, many things has become clear. She is also clear. I'm also clear. My assisting counsel is
So,
also clear, my lord.
if that is,
No, my lord, today I'm just wondering today. it will
Sure.
be a Good tea time talk, my lord. In the temple. front.
It will come up.
Expert, all
No, no,
experts
because
are
all
there.
the experts
in the
are
room.
there.
I don't have the.
Pin all, my lord.
Worship.
No, definitely things develops, my lord.
Uh-huh.
Law also develops
It's
only
developing,
after.
my lord. Every day is a.
Oh, the
Discussion matter.
privilege Mr. Kamar has.
No, 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 my lord.
I don't have the privilege
No,
to
my lord,
check
it's not
across
that way. We all try our best, my lord. No, my lord, we all try our best, my lord.
hypothesis. Thursday?
Lordship, on Friday, can it be 15?
Let me address on
madam,
14.
Friday.
15 or on Monday, this bench is available.
Friday will be difficult. I will have some
Yeah, let me
personal matters, travel matters.
My lord, only request will be, can it be treated as a partner and take?
No, no, I have not opened file.
No, no, because some good things are coming out, my lord.
Oh, put across.
Well,
Anyway,
whichever
it
way the
is.
judgment goes, we are not.
No, because it is
My lord.
always difficult.
Lady Lordship will go. But on 20 then, 20 then.
If I am not there, then you convey it. What is?
We'll try on 14.
14 or 20, whatever.
Oh, he's suggesting to do.
No, no, if it disturbs you on,
You have-
20, that will go for 20.
These are to be on 9.
9. 9.
Oh, thought upon 9.
Friday will be difficult.
2021 any day to fill. Be sectors. If we get some time, we can study more, my lord.
Friday will be difficult from
Let it be on 14, we'll try, my lord.
14 or 14? 14 or you want 20? What?
My lord, as your lordship,
These are, I may not
be sequence.
Not,
be.
you are not
may be
available.
Here.
Okay, let us
Let us
14.
try on 14.
My lord.
Outcome of the matter.
Hmm.
That was regarding the husband for availing casual leave for a few days.
Okay.
And this is regarding the wife. Now the grievance is, 2 show cause notices have been issued and I have given the reply. Nothing has proceeded from then onwards. However, there has been an adverse remark given over my ACR for which period my employer was not there. That also apart, my lord, my salary has been withheld. So my prayer is if notice is issued and a direction is given to release my salary. That is
Which part? Salary?
salary, my lord, page 53. Page 53. Inform that salaries
You are serving.
I'm serving. I'm a copyist in that establishment. And from January 5th onwards, my salary has been withheld. The statement has been enclosed along with my employer's letter.
Forwarding salary.
And the very next page is the statement provided to me.
53.
53 is the letter, 54 is the statement. From that day when I availed casual leave, 5th of January, so the salary was given till 4th, and from then onwards.
Yes, Mr. Sharma. First you take instruction as regards salary then. Next week or Friday you can take.
Husband's case is.
Because, no, regarding salary first,
Yes.
because this code will not be available. Friday? Okay, let us,
But on 22nd, the other matter is fixed. Because even though the issues are not same, but the persons are similar.
okay,
22nd.
let us see about the salary first. Mr. P. Bhardwaj heard. Land Council for the petitioner. And Mr. N.K. Sharma, Land Council, representing Mr. H.K. Das, and Council to Guwahati High Court for the respondent number 1, 2, and 3. Mr. Bhardwaj has submitted that the petitioner. You are not put under suspension.
No.
Has been serving as a copyist
Right.
in the establishment of the respondent number 3. Was the but, comma, but from 4 4-1,
5-1.
5-1, 2024 onwards, the petitioner for the period from 4-5-1-2024 onwards, the petitioner has not been paid the salary. So stop. Mr. Sharma, Council paying for response number 1, 2, 3, has sought for listing of the case on Friday
15-3.
in order to enable him to obtain instruction as regards non-payment of salary. On the other aspect, we'll deal with on Friday.
No place.
You need copy? Okay. If Mr. Borders, Learned Counsel for the petitioner, should furnish a copy of the petition along with an excerpt to Mr. Sharma during the course of the day. To enable Mr. Sharma to obtain the necessary instructions.
In this matter, what took me grant us to stamp the file order at the different. Item number 2, we have received the brief recently, Lord.
Okay.
Earlier it was- there was a condition added.
But since 2021, it is pending, my lord, and for a affidavit.
Okay, Mr. Nair was there.
It's
Yeah, Mr. D. Chaudhary. Alright, Mr. D. Chaudhary, Learned Counsel for the. You are appearing in both the cases.
yes.
You will file counter in both.
Lord.
And Mr. N.K. Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel, GHC. For the response number 2 and 3, 2, 3 and 4. 2, 3 and 4. Mr. Sharma has submitted that necessary instructions have been received to file the counter affidavit on behalf of the state respondents. And thus the counter affidavit will be filed. Mr. Chaudhary, this code is not available for 2 weeks. After it is in the month of April.
Yes.
Uh,
After due.
release the cases on 19/4/2024 for filing a counter affidavit by the
Item 4 for orders.
May it please your lordship. My lord, in this matter, on the basis of anonymous complaints, I am being, my lord, subject to suspension and disciplinary proceeding. Thereby, my lord, serious prejudice is being caused, my lord.
No, what is this IA?
My lord, IA we filed because when we moved the petition, this honorable court passed an order that no final decision should be taken in the disciplinary proceeding. But my lord, the disciplinary proceeding proceeded. Now, for stay of the disciplinary proceeding, we filed the IA, but no substantial order was passed. In the meantime, proceeding is almost complete, my lord.
Okay, to this meaning thereby that the consideration of the writ petition will do.
Yes, my lord. And my lord, lordship will kindly consider, I have been made to suffer suspension on the basis of anonymous complaint. Your lordship, I filed a writ petition. Your lordship issued notice, they immediately registered me. Now, on the basis of same anonymous complaint, I have made to suffer, my lord, disciplinary proceeding. Why should I go through the ordeal, my lord? And the aspect, this aspect.
Yes, Mr. Sharma,
Yes, protected lordship.
What protection?
Has been passed and lordship already.
you are working.
Yes, I'm working. Lordship will kindly see now, my immediate 2 seniors in the gradation list has been promoted. Next is my turn. Lordship, I've already suffered suspension. Now my promotion will be held up, my lord. So, lordship.
Lordship, we have prepared the affidavit and sent it for bidding, Lord.
Okay. Things have progressed then from Mr. Sharma's end. Mr. Patwari,
My lord.
you are already protected in what manner?
My lord,
Okay, no
lordship-
final order.
Yes, lordship will kindly pay the order
Okay,
dated 11/8.
so things will not come against you till the disposal.
No, that I understand.
Try to find out, we'll dispose of as soon as they file.
No, my lord, they have already taken time 2-3 times. Let them take time, but they should file affidavit.
Okay, now he has sent it for vetting, meaning thereby it would come.
Yes.
Mr. Then we'll close this IA.
Let it be there, Lordship, in the final, when the matter may be taken up.
What is here? What is here?
We have prayed for stay of the disciplinary proceeding, entire disciplinary proceeding. But in the meantime, it had proceeded, but in view of your Lordship's order,
Then if this I is to be done, this is to, this
then Lordship can,
creates
Lordship can prove.
difficulty in the sense that this I have to rotate through
I know.
because
I understand. Lordship can close the eye. We'll press.
Justice Soikia's order.
Right.
Justice-
Justice Honorable Justice Suman Sam's order to list it before the appropriate court.
Otherwise, writ petition is before me.
Your Lordship being the portfolio judge,
This is not somewhat
Lordship will close the
some
eye.
complexity. Okay, I do, Honorable Duke, as agreed to by the learned, Mr. J. Patwari, learned counsel for the applicant, repetition and Mr. N.K. Sharma, learned counsel appearing on behalf of Mr. representing Mr. H.K. Ras, learned standing counsel DHC. The instant interlocutory application stands closed. Heard Mr. J. Patwari, learned counsel for the petitioner. Repetition, huh?
Yes, madam.
And Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, standing counsel GHC for the respond number 2 and 3. Full stop. Mr. Sharma has submitted that the counter affidavit on behalf of the respond number 2 and 3 has already been prepared and the same has been sent for vetting. Full stop. He has submitted that the counter affidavit will be filed within 2 weeks' time. Full stop. Release the case. Mr. Patwari, maybe you. 18,
Madam.
19 for 2000. 24. Full stop. In the event, the counter affidavit is filed on behalf of the respondent number 2 and 3, the petitioner may file its reply affidavit on or before the next date of listing, if so advised. If so advised.
Interim to continue.
Other interim order passed earlier shall continue.
Deeply.
How to assess the defense witness? The plea of Levi? I think standard is more. In case of plea of Levi. It sounds plea of Levi similar to what? Plea of Levi আছে। আমার আছে নাকি? আমি কি করবো? বলছি। Itu siapa? Kita apa itu? From the evidence of the prosecution witnesses, from the testimonies of the prosecution witnesses, are discussed above, what have emerged are that uh, on receipt of telephonic information, the eye of the case, PW 11 entered a general diary entry being ZD entry number 11 dated 7/4/2010, and thereafter, proceeded to the place of occurrence, that is the bank of Golondi River, full stop, finding last team near the bank of river, a dog was pit, and a dead body was dug out. Full stop. By a dead body was exhumed. Full stop. The dead body was identified to be of Renuka Hasda. Full stop. The executive magistrate, PW 9 conducted inquest on the dead body of the deceased on 7/4/2010. Wide exhibit EXT4, inquest report. Full stop. Thereafter, the informant, this PW6, lost the FIR. Routine bracket EXT5. Before the officer in charge, Udalguri Police Station on 7/4/2000. 10. Full stop. Better. It is settled in law that oh no, the plea taken by the accused appellant herein is the plea of alibi. Full stop. It is settled in law that when a plea of alibi is taken by an accused, the burden is upon him to establish the same by positive evidence after the onus as regards presence on the spot or on the presence of the accused at the place of occurrence is established by the prosecution. Full stop. While weighing the plea of alibi, the same has to be weighed against the positive evidence laid by the prosecution. Full stop. Para. এই যে বোল্ডার আছে না বোল্ডার বোল্ডার আছে না PW1 was the treating doctor, right? Of PW6.
Of PW6.
हे बोलतू हाँ बोलतू. In her testimony, the informant, yes sir, PW6. Had reports to the effect that she lost the affair and the disease was her elder sister. Full stop. PW6 stated that she knew both the accused persons. Narrating about the incident, she deposed that both the accused persons were her co-villagers and she knew them well. Full stop. It was around 12 o'clock midnight. Both of them came to the house of PW6 and the deceased and asked to open the door. Full stop. Recognizing their voices, Renuka Hasda opened the door